Hi, Aurelio.
Hello over there. How are you, Jason?
Very well. How are you? Resume recording. There we go. Well, good evening, everyone, if you're in the Southern Hemisphere, and good morning if you're in the Northern Hemisphere. Welcome to another webinar offered by the Parsons Centre for Commercial, Corporate and Taxation Law here at Sydney Law School. And this series is called the Downtown Law and Business webinar series. And the goal is to have a range of academic speakers, not only from Sydney Law School, but from all around Australia and indeed all around the world, to present some of their current research and current thinking around law reform, particularly in the areas of corporate and commercial law. The webinar this evening is going to be focused on insolvency reform. And for those of you who are regular attendees in this webinar series, that's been one of the enduring themes of 2020 and no doubt will continue into 2021. Our speaker tonight is Aurelio Gurrea-Martínez, who's Assistant Professor of Law at Singapore Management University, and he's also the head of the Singapore Global Restructuring Initiative at the Singapore Management University Centre for Cross-Border Commercial Law in Asia. And for those of you who are following developments in insolvency reform in Singapore, you've no doubt seen some of the many articles and blog posts that Aurelio has been posting up on LinkedIn and also on the Centre's blog. So I'll give that a plug. And you certainly should be following the Centre's blog activities because it's really amazing, Aurelio. You have a number of blog authors from all around the world. So we've got bankruptcy judges, we've got partners from law firms, we've got professors from all around the world. So it really is a wonderful source of information, not only on Singaporean insolvency law reform, but on insolvency law issues all around the world. So I've asked Aurelio to present for us tonight an overview of Singapore's omnibus insolvency law. So some of you might be familiar that was introduced earlier this year, but it certainly has been a long time coming. And the reason I've asked Aurelio to join us tonight to discuss Singapore's omnibus insolvency law is because, as you would be aware, for those in Australia, insolvency law reform has certainly been a big topic this year. We've had the government announce a range of reforms, including some COVID-specific reforms, some of which will be finishing up at the end of this year. And I know Aurelio has been doing quite a lot of work on how different jurisdictions have been responding to COVID. And so he's going to tell us about Singapore's insolvency law, but also how Singapore's been responding to COVID. And as always with these Downtown Law and Business webinars, particularly when we have an overseas presenter, I like to have a local practitioner who can offer the local perspective on the keynote presenter's topic. So our commentator for tonight is Paul Aparthy. Paul is a partner here in the Insolvency and Restructuring team at Herbert Smith Freehills in the Sydney office. And Paul's had a lot of experience all around the world in insolvency and restructuring, including in New Zealand, in Asia and in Europe. And Paul has actually written a number of articles comparing Singaporean insolvency reform with Australian insolvency law in the Insolvency Law Bulletin and other publications. So thanks Aurelio, thanks Paul, both for joining us tonight. And I'll now hand over to Aurelio. Just while you're getting your slides up, Aurelio, for those in the audience, if you did want to ask any questions as we're going through the discussion, you can post up a question either in the Q&A box or under the chat function on your toolbar, and then we'll answer those questions at the end. I'll also note that this session is being recorded, and so all registered attendees will get a copy of the recording in the next few days, and we'll also post it up on the Sydney Law School website. Aurelio, are you happy for your slides to be distributed to registered attendees?
Yeah, sure. That would be great. Yeah.
Wonderful. Thanks very much.
Okay, so first of all, thank you so much, Jason, for the opportunity to be here today. It's a great honor to be part of this amazing webinar series that Sydney Law School is organizing under your leadership. So my sincere gratitude for the opportunity to share a few thoughts about what Singapore has done in the past few years. Also, I would like to thank Paul for the opportunity to provide feedback and comments and compare what we're going to discuss in Singapore with what Australia is doing. So thank you so much also, Paul, for the opportunity to be here as well, joining us. So I'm going to divide my presentation into two main parts. The first part is going to be focused on the general insolvency and restructuring framework that Singapore has implemented in the few couple of years, with particular emphasis on Insolvency, Restructuring and Dissolution Act that came into force by the end of July, so just a few months ago, even though the most significant part of the act already came into force in 2017 and 2018. And I will pay more attention particularly to the new restructuring tools that Singapore has implemented. So basically rescue financing, cross-class cram-down, restriction of ipso facto clauses, and similar provisions. And then the second part of the presentation will be focused on the Singapore response to the COVID-19 crisis, with particular emphasis on the new simplified insolvency program that Singapore has implemented, or it will implement soon because it has been already discussed in Parliament, but it hasn't come into force yet, in order to deal with SMEs in insolvency. So just a brief overview about what we had before the 2017-18 reforms. So we had a dispersed legislation because we had part of the insolvency restructuring framework in the Companies Act. Then for individuals, we had also part of the insolvency legislation in the Bankruptcy Act. The procedures were not very efficient, or at least there was significant room for improvement, particularly in the context of the scheme of arrangement, because the scheme of arrangement in Singapore was inspired in the Commonwealth scheme, the UK scheme, but with some differences, because unlike the UK scheme, for example, in Singapore, the UK scheme already allowed a type of moratorium, and this is something that doesn't exist under the UK scheme, but it was a very restricted moratorium. And as we will see now with the new restructuring framework, we have implemented a much more powerful moratorium. And then the judicial management, which is the equivalent to the administration procedure in the UK, was also relatively inefficient and criticized because it didn't provide, for example, debtors with rescue financing provisions. It didn't allow cross-class cram-down. It also was based on the idea of having an external administrator, a judicial manager appointed to run the case. And that was also, according to some authors, that's why this procedure has never been very successful. And that's why the STAR procedure in Singapore has always been the scheme. So that's why we felt that we needed to modernize these procedures. And we felt, and this is based on a fantastic report that was prepared by a group of experts appointed by the government in 2013. There was a commission suggesting a few changes, and they also emphasized the fact that if we amend the procedure, it would be useful also to modernize some of our existing provisions to, for example, favor litigation funding, in order to modernize avoidance actions, and in order to modernize other insolvency provisions. So that's why in 2017 and 18, there was a bunch of reforms, so two main reforms, and these reforms ended with the enactment of the Insolvency, Restructuring and Dissolution Act that was passed by Parliament in 2018. But the act came into force last July, so the 13th of July, among other reasons, I guess, because first of all, probably the government wanted the insolvency community to be familiar with the act. So that's why they provided this 1.5, almost 2 years space in order to become familiar with the act. And probably, and more importantly, because the act has been now implemented along with a substantive volume of subsidiary legislation. So that's why, in order to make sure that the act is working well, it was important also to commence the act along with this significant volume of subsidiary legislation. And these reforms basically took place not only because the government felt and the industry felt that it was needed to modernize Singapore insolvency and restructuring laws, but also because it was another way to keep promoting Singapore as an international hub for debt restructuring. So that's why this is one of the most important motivations for the reform, to strengthen Singapore's position as an international hub for debt restructuring. And that's why what this group of experts did is to explore the best practices for corporate restructuring around the world, looking at Australia, the UK, the US, Europe, from all over the world, and then to try to implement, in some cases with some significant divergences from what, for example, the US Chapter 11 has, the most appropriate provisions in order to make sure that, first of all, the new restructuring insolvency system works with the particular legal, economic, and institutional features of Singapore, and also to make sure that the new insolvency and restructuring framework can also position Singapore as an international hub for debt restructuring. So the main features of these 2017-2018 reforms, all of them included in the Insolvency, Restructuring and Dissolution Act, are summarized in this slide. So on the one hand, if we want to become an international hub for debt restructuring, we need to allow foreign debtors to come to Singapore. So that's why one of the reforms was to expand the jurisdiction of Singapore courts over foreign debtors. And this is done by requiring only a substantial connection with Singapore. So that's why foreign incorporated companies can come to Singapore if they show substantial connection. And what is substantial connection? Well, it's, for example, having contracts subject to Singapore law. It's having significant assets in Singapore, main business in Singapore, center of main interest in Singapore. And in fact, there was an interesting case, an Indonesian company with almost everything located in Indonesia, but the company had some bonds listed on the Singapore exchange, and the Singapore High Court understood that this is also substantial connection with Singapore. So that's why it allowed this Indonesian company to apply for the Singapore moratorium and to use the Singapore restructuring regime. Then also in 2017, and this is also included in the Act, we adopted the model loan cross-border insolvency. And in fact, I would say that Singapore has been one of the most important supporters of international coordination and cooperation in cross-border insolvency. In fact, some of our judges are also some of the founders of the Judicial Insolvency Network, which is this network of bankruptcy judges from Delaware, New York, the UK, and other places to promote this cooperation in cross-border insolvency cases. Also, we felt that we needed to have a licensing regime for insolvency practitioner. So that's why now a license is required, and acting as an insolvency practitioner without a license is considered an offense. Also, we needed to modernize our transaction avoidance. Because, for example, the twilight period for transactions at an undervalue. So for transaction avoidance, we have the system basically existing in many jurisdictions in the Commonwealth. So that's why we divide, among other type of avoidance actions, we have transactions at an undervalue, and we have the avoidance also of unfair preferences. For transactions at an undervalue, the twilight period was 5 years before the reform. And we felt that 5 years is a very long period. It can create legal uncertainty, etc. And that's why this twilight period was reduced from 5 years to 3 years. And then also the twilight period for unfair preferences was also changed because for related parties, it was expanded from 6 months to, for related party was 2 years. And for non-related parties was expanded from 6 months to 1 year in order to make it like more consistent also with the twilight period for transactions at an undervalue. Also, we felt, and this is something that Jason's research has highlighted, and many other scholars, that sometimes one of the problems with wrongful trading and with avoidance actions is that many companies don't have the funding needed to pursue some actions against counterparties, against corporate directors. So that's why we thought that one way to promote these type of actions, and therefore to create a deterrence effect that these actions are supposed to create ex ante, in order to achieve these goals and simultaneously promote more recoveries for the creditors, it was important to promote a system of litigation funding. So that's why under the new restructuring framework, also the judicial manager and the liquidator can assign some of the proceeds to some external funders. And this is supposed to be good to promote more litigation funding. Also, the wrongful trading regime was changed. And for that purpose, by the way, apart from Jason's fantastic work on that, Paul has also written about the wrongful trading regime in a fantastic article summarizing the insolvency reforms in Singapore. And basically what we did with the wrongful trading regime is to explore the Australian regime, to explore the UK regime, to explore different regimes around the world. And we adopted a concept of wrongful trading regime, but it's not the concept of wrongful trading generally existing in the UK. Because in the UK, the wrongful trading regime basically implies that once the company becomes insolvent, or once the directors realize that the company will end up in an insolvent liquidation, they need to take steps to minimize losses for the creditors. This is not the concept of wrongful trading existing in Singapore. Our concept is actually one of the different concepts of wrongful trading that was explored by the Cork Committee in the United Kingdom, and it's actually similar somehow to the system existing in New Zealand, and it has some similarities also with the Australian system, because under the Singapore regime, the company is going to be trading wrongfully if the company is insolvent and it borrows money, but it's unable, or the directors think that the company will be unable to pay these new debts in full. So that's why it is similar somehow to the Australian regime, in the sense that once the company becomes insolvent, or with the new debts can become insolvent, the directors need to do something, but it is probably less strict than the Australian regime, because in Australia is you cannot do something unless you do these provisions that we provide with the safeguards. So basically to engage in a restructuring that can be beneficial for the creditors. While in Singapore, even if you are insolvent, you can keep trading, you can keep borrowing money. The provision only applies if you think that the new debts are not going to be paid in full. And also following the Australian approach with amendments in 2017 with these safeguards for wrongful trading, Singapore has implemented several safeguards as well. So for example, if the directors acted honestly, then, and that's why a kind of business judgment rule will probably apply, and the directors might not be liable. Also, the directors and their counterparties, because under the new regime, the counterparty can also become liable. So basically, the counterparty will need to act as a kind of gatekeeper to make sure that the company is not trading wrongfully. They can ask the court for approval, and if the court approves the transaction, then both parties are going to be safe. So that's why there are certain provisions to protect corporate directors. And also another important reform in the context of wrongful trading is that under the previous regime, in order to impose civil liability, a criminal conviction was required first. So that's why it was almost impossible to have civil liability. So now we have abolished that requirement, and now you can impose civil liability first. And then, and this is probably one of the most important reforms in order to promote Singapore as an international hub for debt restructuring, we have adopted several restructuring tools. So the first one is to enhance our existing moratorium for the scheme. Now, the enhanced moratorium will be available to debtors intended to propose a scheme of arrangement, and they will enjoy an automatic moratorium. So it's somehow inspired in the automatic stay existing in the US. It will be a 30-day automatic moratorium that can be extended. And more importantly, this moratorium, unlike the previous one, will affect secured creditors. It can affect related companies within the same corporate group, and it will have worldwide effects. And in order to prevent the opportunistic use of this moratorium, the court will be analyzing on a regular basis the desirability and the need to grant extensions to the moratorium. Then we have implemented rescue financing provisions, inspired also in the debtor in possession financing, deep financing provisions existing in Article 364 of the US Bankruptcy Code. But we have implemented this provision with some important differences as well. Because first of all, we define rescue financing as new financing that can facilitate the survival of the company or a more beneficial realization of the debtor's assets. And there are some significant differences, because in the United States, for example, for debts, for new credit that is obtained and in general conditions, and also in the ordinary course of business, the debtor or the trustee, the debtor in possession of the trustee can obtain the new financing in the ordinary course of business without court approval, and still the new financing will enjoy the administrative expense priority. In Singapore, we require court approval for any type of priority. And as we will see in a minute, there are different types of priorities. So first of all, the court need to be convinced that this is rescue financing. So that's why survival of the company or more beneficial realization of the debtor assets is essential. Also inspired in the case law in the United States, our courts, in some of the first cases already deciding on the rescue financing provisions, has required, and this is incredibly important, that the creditors as a whole has to be better off with the new financing. So it has to be beneficial for the creditors. So that's why the new financing is supposed to either create value or at least to minimize the destruction of value. Also, no alternative financing available. The terms of the offer need to be fair. So that's why all of these conditions need to be met in order to authorize the new financing. But then even if the court authorizes the new financing, it can do so using 4 types of priorities. And this is, for example, very similar to the different type of priorities existing under Article 364 of the Bankruptcy Code. First of all, we have the administrative expense priority. So basically, the deep lender will enjoy a priority in the case of liquidation. So it will be paid along with some liquidation expenses. And in order to enjoy that priority, the debtor needs to show that it has attempted to borrow money and it was impossible to obtain money and in order to enjoy that priority. The second type of priority, because many lenders might say, yeah, but you know what? Professional advisors, lawyers, many others will also be part of the liquidation expenses. So I want to be the first one in line among those liquidation expenses. So this is a second type of priority that can be granted. The burden of proof is going to be higher. And among other reasons, now not only you need the reasonable attempts to borrow otherwise, but you need to show that you are totally unable to borrow money otherwise. You really need the money from this lender. And also the court will need to show that this is beneficial for the creditors because it's going to create value or at least preserve and minimize the destruction of value. This is the second type of priority. But still maybe the deep lender or the potentially deep lender might not be happy with that. And they want something else. They saw that, for example, there are some unencumbered assets, or they want to be part of, they want to take a collateral as a junior secured creditor. And they say, well, I want a collateral. And this is possible as well. So if there are some unencumbered assets, then deep lender can have access to these unencumbered assets as a collateral if it is authorized by the court, or they can become a junior, they can get a junior lien on an asset already secured. But in order to do that, again, the debtor needs to show all of these requirements plus the inability to borrow otherwise. And then if that's not enough, and the creditor says, you know what, you don't have any unencumbered assets. So that's why priority 3 is not possible. You only have one asset, and this asset is already subject to a security interest. So unless I am the first one in line over this collateral, I'm not going to lend you money. So that's why another possibility is the 4th type of priority, which is priming existing liens and become a senior creditor over an asset already subject to a security interest. This is theoretically possible, but in order to be possible, in addition to those requirements, general requirements that I mentioned, also the secured creditor affected by this change in the priority over the collateral need to be adequately protected. And the concept of adequate protection is inspired also in the US Chapter 11. So basically cash payments, also unencumbered assets or an additional lien, or indubitable equivalent value, which is basically an equity caution, and then also inability to borrow otherwise. So far, we have several cases on debt financing, rescue financing in Singapore, And we have used already priority 1, 2, and 3, but not 4. In fact, I'm not sure if we will be able to use priority 4, because priority 4 is not even used very commonly in the United States either, because of the adverse effect that can create on lending markets from an ex-ante perspective. Also, it's not easy to provide adequate protection because, again, as I mentioned, cash, no, you are not going to provide cash if you are insolvent. Junior, new additional liens, probably you are not going to have an encumbered assets. An indubitable equivalent value, then you will need to show the equity caution, and it's not always the case in this type of company, because if you have an equity caution, why not using priority 3? That is the opportunity to allow the deep lender to have a junior lien over an asset that is already subject to security. So I'm not sure that our courts will be using 4th. It's not generally used also in the United States. And in fact, even with the most basic type of priority 1, our courts have been very prudent, very skeptical, because they are aware that even if the priority 1 is given, then by giving administrative priority, the rights of unsecured creditors will be affected. The pie available for distribution will be reduced for unsecured creditors. So that's why our courts, I think, have taken a very conservative approach. And I think that that's the right approach when it comes to debt financing, because the courts need to verify that the financing is going to create value or at least preserve value. And if the court allows this type of priorities, even the first one, the rights of other creditors are going to be affected. So that's why in order to affect those rights, the court needs to make a very careful assessment of all the conditions. And that's why most of the priority that has been given so far are priority 1 and 2. And then interestingly, in the wording of the legislation, for priority 1 and 2, the legislation said that it will provide this priority for financing obtained or to be obtained. And for priority, there is a typo here, for priority 3 and 4, it says that it's for financing obtained, not for financing to be obtained. And why is that relevant? Well, that is relevant among other aspects, for example, in the context of roll-ups and the context of cross-collateralizations. So we have had already one case of a roll-up. The typical pre-existing lender, they say, yeah, I'm happy to be the deep lender, but in order to have this, in addition to the priority for the new financing, I want you, debtor, to provide me also with a priority for my pre-existing unsecured debts. I want you to pay some of these pre-existing unsecured debts with the administrative expense priority. So that's not formally allowed in the legislation, but because of the wording said financing obtained or to be obtained, so then some courts have interpreted that roll-ups, at least so far, are allowed in Singapore because after all, the unsecured debt was money already provided to the company, so it was financing obtained for the company. But as it happens in the United States for roll-ups, also the court needs to make sure that the new financing is going to create value or is going to preserve value. So that's why our courts, I think, have taken the right approach when dealing with debt financing, which is to be very conservative and to make sure that the new financing is value creating. Also, we have adopted from the US Chapter 11 the idea of the cross-class cram-down, but again, with some differences as well when compared to the United States, because in addition to the approval of at least one class and the condition of that the plan cannot discriminate unfairly, and also the fair and equitable plan, which basically means in the context of Singapore, in the United States, is more respecting the absolute priority rule, while in Singapore is divided into the best interest of creditor test and the absolute priority rule. So there are some differences here because, for example, the best interest of creditor test is not defined in the United States by the case law, shows that the test that is generally used by courts is the scenario of a hypothetical piecemeal liquidation. So orderly piecemeal liquidation is the hypothetical scenario under the best interest of creditor test in the US, while in Singapore is the most likely scenario if the agreement fails. And the most likely scenario if the agreement fails is probably be maybe judicial management, going concern sale, so not necessarily piecemeal liquidation. So this is one difference from the US. Also, another important difference is that in the United States, if you have the approval from one class, you can impose the plan on the dissenting classes of creditors, provided that the plan doesn't discriminate unfairly and the best interest of creditor test and absolute priority rule are met. Well, in Singapore, that's not enough. We need also an overall approval of at least a majority number of all the creditors, and also 75% in value of all the creditors. So that's why in the United States, for example, it's much easier to use the cram down provisions than in Singapore. But I guess that this requirement was probably justified because we're coming from a very pro-creditor jurisdiction. And that's why if you directly impose the cram down provisions existing in the United States, I think that our industry still needs time to make sure that the best interest of creditor test works, the absolute priority rule works, to make sure that even with the best interest of creditor test and the absolute priority rule, I think that creditors are going to be totally protected. To be honest, I don't personally think that this 75% requirement is going to be needed to provide the protection to the creditors, but I think it was a wise decision to adopt this, because in the absence of this provision, maybe the market might respond to this provision by saying, hey, we are unprotected. One single class of creditor can impose the plan on the remaining classes of creditors. So we're going to immediately respond by increasing the cost of debt in the country, and that can be bad for lending markets. So that's why I thought that at least in the first implementation of the cram down provision, it was a very wise decision. Interestingly, also, we have adopted this idea of the pre-pack schemes. When we speak about pre-pack schemes, the idea existing in the UK is different from the pre-packs existing in the US. We have implemented a pre-pack scheme that is similar more to the US, because basically everything is negotiated out of court, and then it's a scheme of arrangement, but with some differences. The most important is that the debtor needs to apply only once to the court, just for the approval of the scheme. So that's why you are supposed to negotiate ex ante with your creditors, you are supposed to negotiate out of court, and then you ask the court just for approval. And then the agreement is going to be approved by the court, even without any creditors meeting. So the court will be approving the scheme if it is satisfied that the agreement could have been approved by the meeting of creditors. And that's why it's based on a hypothetical approval. The court doesn't specify how to show evidence about this hypothetical approval. So that's why in some successful cases of pre-packs that we have had so far, what the lawyers have done is to show a significant support from the creditors in order to tell the court that, hey, most of our creditors are supporting this. Our only problem is just with a few dissenting creditors. So it's almost like a workout, but with ability to impose the plan on some truly minor creditors, dissenting creditors that are not in favor of the plan. So creditors will still be protected based on some disclosure requirements, the court review, etc. And also, interestingly, for the pre-pack scheme, the cross-class cram-down provision that I have just explained doesn't apply. So that's why we need a traditional approval for the scheme, which is majority number and 75% in value of each class. We have also adopted the restriction of ipso facto clauses, and this is something that is more commonly being adopted in many jurisdictions also around the world. In Australia, you guys have something similar. So basically, the counterparties cannot terminate the contract just because the debtor has initiated an insolvency restructuring procedure or because the company has become insolvent, but there are certain exceptions. So as it happens in most countries around the world, there are exceptions for financial contracts, contract and licenses with the government, and some contracts affecting national security or the economic interests of Singapore, etc. But interestingly, I would like to emphasize two main aspects here. One is that even if the counterparty cannot terminate the contract because of the commencement of a formal restructuring insolvency procedure or situation of insolvency, they can terminate the contract for other reasons, including, for example, the debtor's failure to pay. So default on payment can be one reason. So this is one important exception as well. And also, and I think this is also a very wise decision, sometimes one of the main problems with the termination of ipso facto clauses is that the counterparty might be harmed, might be forced to stay in the contract, and that can lead even to a situation of insolvency of the counterparty. Well, if the counterparty shows that they will experience financial trouble because they are not allowed to terminate the contract, if they show this financial hardship, then they will allow to terminate the contract. They can apply to the court, and the court will allow the termination of the contract. And then, even though we have implemented, many tools existing in traditional organization procedures, still the scheme of arrangement is going to be based on a DIP model. So that's why the directors will be running the company, and actually they will be running the company without the formal appointment of an insolvency practitioner, as it happens, for example, in the United Kingdom, where a monitor supervisor is appointed to supervise the moratorium. So in this case, in the case of Singapore, insolvency practitioner is not required, even though it's common for schemes, particularly for the implementation of the scheme, to appoint a scheme manager. Okay, so this is the picture of what Singapore has done in the past years. And now very briefly, because I know, Jason, that I am running out of time, now very briefly, just what we have done in the past months with the rise of the COVID-19 crisis. So basically, Singapore has implemented a very comprehensive response to the COVID-19 crisis, including financial support, a very generous financial support, around 20% of the country's GDP. Also, it has encouraged workouts, and some legal responses, some of them summarized in the COVID-19 Temporary Measures Act. This act includes some special rules for contracts, a very interesting notification of relief, which is a type of out-of-court moratorium. If the debtor is unable to pay, they can notify that to the lenders, and then the lenders cannot initiate any enforcement action, legal actions against the debtor. If there is any controversy with that situation, because the debtor might be opportunistically using that, then there will be some assessors appointed to evaluate that. And then in terms of insolvency reforms, we have implemented something similar to what Australia implemented. So to make more difficult for the creditors to initiate insolvency proceedings, also to temporarily suspend the liability for wrongful trading, and also something that I don't think Australia has done, but other countries have done, for example, the Czech Republic, which is to extend the look-back period for avoidance actions, while in the case of Singapore, the debtor is enjoying this notification of relief, because the notification of relief will serve almost as an out-of-court moratorium. So that's why that period is not going to be counted for the purpose of avoidance actions if the company at some point in the future becomes insolvent. But that was what Singapore did in the first phase, in the first stage of the pandemic, which is basically with the purpose of putting the economy into hibernation. Now we have realized that we need to promote recovery, and that's why the government is taking new responses, because the economy cannot be put together into hibernation. We are creating also zombie companies. If we do that, contagion effects and creditors also becoming insolvent, non-performing loans that can even jeopardize the stability of the financial system. So that's why we need to take actions. And what the Singapore government has done is to keep promoting negotiations and workouts, also to promote new refinancing agreements for sole proprietors and partnerships. Also, MAS, the Monetary Authority of Singapore, is working also with some banks, also to try to encourage these banks to promote this deferral on payments, so at least the principal repayment of secure loans. Also, the government has implemented something called the Realign Framework, which is basically when to allowing parties to terminate a contract without paying termination fees. So that's why they can still, they will still owe the unpaid debts, but at least they can exit the contract without paying for these termination fees if they are unable to renegotiate the conditions of the loan. Then also the notification of relief has been extended just for very limited contracts, mainly with developers. Apart from that, this also has been expired, as the other insolvency temporary measures have expired as well. And more interestingly, the government has implemented a temporary insolvency framework for SMEs. So this insolvency framework is called the Simplified Insolvency Program. It's divided into simplified organization procedures and simplified liquidation procedure, and it is managed by the official receiver, which is something that, by the way, that some authors have suggested, including Professor Jason Harris and also Michael Murray, have suggested that because there is a type of market failure here, some of these SMEs are unable to fund the procedure. So that's why we probably need more intervention from the government. And we will see that this is actually the approach that has been taken in Singapore. In order to have access to their procedures, the concept of SMEs is less than 10 million in sales, less than fewer than 30 creditors, and then 30 employees, 50 creditors, 2 million in liability. So this is different from Australia. From what I know is 1 million in debts, in liability. And then interestingly, only for simplified winding up, we require that the debtor needs to have less than 50,000 in unencumbered assets. And why is that? Well, I guess that the rationale behind that is because if you have more than 50,000 in unencumbered assets, maybe you can afford paying for an insolvency professional, you can afford initiating a formal liquidation procedure, and you might not need this simplified liquidation procedure. But in addition to the legibility, which is basically to be an SME, based on this definition, you need to be suitable. And in order to be suitable, for example, for the simplified organization procedure, you need to show that you have a chance to really reach our organization agreement within the 90 days period provided in the legislation. And in fact, if you don't have the majority needed, 1/3 of the creditors can even reject that application from the debtor. So in other words, what the Singapore government has suggested is to impose a kind of ex-ante control there to make sure that the simplified organization procedure is not going to be used opportunistically. So that's why the debtor needs to prove certain stuff. And then also for simplified liquidation procedures, we have among the suitability requirement that the debtor might not be subject to other type of legal insolvency procedures. So for the reorganization procedure, as it happens in Australia, we will require the appointment of a restructuring advisor. The restructuring advisor is appointed by the official receiver, and there will be a system of co-payment. So this is something interesting as well, realizing that there is or could be a market failure here. So that's why there will be a system of co-payment, because the restructuring advisor might be a private actor, an insolvency practitioner. So that's why the fees charged by this practitioner will probably be co-paid by the official receiver and by the debtor itself. Then once the debtor is accepted to this program, it will enjoy a moratorium and restriction of ipso facto clauses. And the debtor, working with a restructuring advisor, will need to come with a plan within 90 days. So the restructuring advisor will be the one formulating the plan. They have 3 months. So the period is much longer than from what I know from Australia. So 3 months to come up with a plan. And interestingly, the plan and the organization plan will be based on the simplified scheme of arrangement, the pre-pack scheme that I just described under the Insolvency, Restructuring and Dissolution Act. So that's why it will require only one application to the court. So just for the approval of the scheme. So that's why no other court applications. And also, and this is also one important difference between the pre-pack scheme and the pre-pack scheme for the purpose of simplified procedure, is that instead of requiring the majority of the creditors plus 75% in value, then for this simplified organization procedure, it will require only 2/3 of the creditors in value. So that's why there is a simplified reduced majority. And the creditors are going to be protected in several ways. First of all, in the petition, because the approval of the scheme requires 1/3 in value. That's why the simplified reorganization procedure requires or allows the creditors to reject the commencement of the plan if 1/3 of the creditors reject the initiation of the procedure. Also, there will be disclosure obligations and then court review and approval. And then for the liquidation procedure, again, will be managed by the official receiver. Interestingly, no court order is needed. This is the general rule for compulsory winding up, but no court order is going to be needed for this procedure. So that's why it is inspired somehow in the creditors' voluntary winding up procedure. And then the official receiver or private liquidator appointed by the government will also be the one running the process. There will be a system of co-payment as well. No creditors meeting. Also, the procedure can end up in 30 days, so only 1 month, if the company is unable to even meet the cost of the liquidation procedure. and the liquidator concludes that no further investigations are needed. Okay, so that's all from my side. My apologies. I know that I exceeded the time that was allocated, but I will be very happy to take any questions afterwards. So thank you so much.
Thanks, Aurelio. I'm amazed at how much material you covered in such a short space of time. Paul, would you like to share with us any thoughts that you've got on what Aurelio's been talking about and what Singapore's been proposing? Sorry, Paul, you're just on mute.
That's the mistake we always make these days. Thank you, Aurelio, for fantastic overview of it's clearly been a huge amount of law reform in Singapore over the last few years. I am quite impressed that you managed to cover so much in that time period. It is a massive topic. So, and I'm conscious that we sort of don't have a huge amount of time. So I'll just sort of dip into a few areas here and there. This is a topic which I could sort of potentially talk to for hours because it's sort of so interesting. I guess sort of taking a step back, I mean, one of the things which I find really interesting about what Singapore is doing is it is being very proactive about restructuring law reform, and it was getting moving on all of this long before it became fashionable, and we had sort of COVID-19, and everybody thought we needed to suddenly sort of reform our insolvency and restructuring laws. Singapore has done this in a very sort of deliberate way, with this aim of becoming a regional or global hub for cross-border restructuring, and it's sort of interesting to see. These law reforms have come in. There've been sort of many other measures that have been taken as well, aside from the legislative ones. Indeed, sort of Aurelio, your role in conjunction with the sort of the broader Singapore Global Restructuring Initiative, I guess, is sort of all part of this broader push by Singapore to become a centre for undertaking these sorts of transactions. It's sort of, to my mind, it's sort of, despite all of the work that has been done, it's still relatively early days in that process. We've seen sort of some cross-border transactions and restructurings being undertaken through the new Singapore model, but a lot of the transactions that I've seen, at least so far, are probably ones that have got a strong Singapore bias already. Or ones that probably would have been conducted through the sort of Singapore processes before these law reforms. There have, of course, been a few exceptions, but I think one of the questions which is going to be really interesting for Australian practitioners and practitioners throughout the region is, where are the situations and the opportunities where the Singapore regime could be used for something that we might traditionally consider to be an Australian restructuring situation. Where does Singapore provide sort of advantages over the tools and the process that we have here, and how do we sort of, as practitioners throughout the region, sort of add that to our sort of broader toolbox of things that we can use to help our clients work through these situations. In terms of sort of the reforms that have been undertaken, I might sort of just make a couple of comments around the scheme regime, first of all, because the sort of schemes really sit at the heart of, I think, a lot of what Singapore is doing in terms of cross-border restructuring. And what I guess has been done there is an interesting sort of fusing of a number of concepts from the US Chapter 11 process with the sort of the more traditional sort of Anglo scheme of arrangement process. And I think sort of some of those things are, probably work better than others. It's particularly interesting to see how the moratorium has been sort of enhanced for the Singapore scheme process. When I first looked at the Singapore legislation enacting the moratorium provisions, my sort of assumption from the way it had been done was that the moratorium was intended to really sort of be there to provide a degree of protection for the group in the period between when a scheme of arrangement had been proposed by a company to its creditors and when it had actually been sort of effectuated and carried out. What's become clear from sort of the cases and the practice in Singapore to date is actually it's sort of got quite a broader ambit, and this moratorium is almost like a standalone process, even though it falls within the scheme of arrangement provisions. And that, I guess, has sort of got advantages in the sense that it is this sort of, in a way, this sort of standalone debtor in possession restructuring tool. But there are also risks with that, given that it's a relatively light touch process with significantly less court oversight than, say, a Chapter 11 debtor in possession process. And we saw sort of some of the risks of that with the high flux restructuring, for example, where the company undertook a restructuring within this sort of this moratorium protection, but it wasn't at all clear for sort of much of the process whether there really was a sort of a viable scheme of arrangement or restructuring to undertake with creditors, and ultimately there doesn't appear to have been one. So it'll sort of be interesting to see whether the experience around that moratorium evolves, I guess, as the sort of courts become more familiar with the different types of scenarios that might play out in practice. Another area of challenge, I think, around the use of the scheme in Singapore as an international debt restructuring tool is one that we grapple with here in Australia as well, and that is in cross-border restructurings. We frequently find that the governing law of the debt instruments are frequently either English law or New York law. New York law is relatively easy to deal with in many cases, but English law debt, we have to grapple with the rule in Gibbs, which essentially says that to compromise English law debt, you need to do it in accordance with English law, and generally that means under an English law scheme rather than a foreign law scheme. So again, sort of to the extent that there continues to be a significant amount of international debt governed by English law, then we may still see a sort of continuing need to undertake either sort of parallel Singapore and English law schemes, or people might decide that sort of the English law scheme is effectively what they need in order to reorganize the debt. I might mention briefly as well the cross-class cram down. That's a really sort of interesting issue as well in terms of what you can do with the scheme. And we've seen in the United Kingdom just recently, there's been a law change there to enact sort of a UK equivalent, if you like, of the cross-class cram down that Singapore has enacted, albeit that the way they've gone about it is slightly different. I think it'll be interesting to see sort of how those two different sort of cross-class cram down mechanics in the UK and Singapore fare in terms of sort of what the benefits and disadvantages of the two regimes are. One of the things which is sort of interesting about the Singapore regime, as you pointed out in your talk, was that there is this sort of still this overall requirement that 75% of creditors as a whole vote in favour of the scheme, regardless of sort of whether those creditors are in or out of the money. And that does sort of create, potentially some difficulty depending on the size of the debt that needs to be compromised. One of the other issues with the Singapore cross-class cram down is that there is no ability to cram down shareholders under the Singapore regime, and it seems with the way that the regime has been amended following the Insolvency, Restructuring and Dissolution Act, that the absolute priority rule, which exists in the US and generally requires that if you're going to cram down a class of creditors, any stakeholders ranking below those creditors receive nothing. that absolute priority rule doesn't appear to apply to shareholders under the Singapore regime, which I gather was something of a sort of a policy choice in Singapore. The scheme of arrangement proposal effectively being a sort of a voluntary proposal by the company. I assume that there was thinking that by having a requirement that shareholders effectively lose all of their rights in the company, that may act as a disincentive for companies and their shareholders to use the process. But it does obviously mean that there is, a sort of an interesting question of fairness and whether there might be sort of room for junior creditors to be to be prejudiced in a situation where perhaps senior creditors have to vote on a proposal, shareholders can't be crammed down, and they manage to retain some of their interest in the company, but sort of junior creditors lose out because they can be crammed down and without a say. The enhanced moratorium, perhaps one other comment about that, which is sort of interesting as a comparison between Singapore and the US. The Singapore moratorium is sort of described as being worldwide, sort of in a similar way to the US automatic stay is sort of broadly considered to be of worldwide scope. There is obviously an important distinction between the US and Singapore in that the US is a much larger jurisdiction, and therefore there is potentially sort of a little bit more force to the orders of the US bankruptcy court requiring creditors not to take action against a debtor. Again, I'm not sure how much we've seen the worldwide stay of the Singapore moratorium really being tested yet. Singapore does obviously have a number of financial institutions now that operate out of Singapore, and therefore you could see that a number of financial institutions would be quite wary of taking action against the debtor company, even if it's outside of Singapore, because they wouldn't want to breach that stay. But it remains to be seen, I think, sort of how effective that is, say, compared to the US worldwide stay. I'm conscious of time. Jason, how do we have a hard stop at 7 or?
We could go a couple of minutes over. I'm also mindful if anyone in the audience had any questions, you can type those up in the chat box or in the Q&A box on your toolbar. But please do continue, Paul.
Okay, thank you. I might make a couple of comments then on the ipso facto regime, which is very interesting, seeing the Singaporean approach to ipso facto, given that Australia has recently introduced its own ipso facto regime. The approach to sort of drafting between the two provisions couldn't really be more stark. The Singapore clause is really just sort of a single section in the legislation and is sort of fairly principles based. The Australian approach has been to come up with very detailed, numerous provisions in the primary legislation applying to each separate regime, and then having a world of exceptions set out in regulations and orders, such that actually navigating the regime in Australia is pretty complex. I certainly appreciate the sort of the simplicity of the Singaporean approach, and it will be interesting to see whether you sort of get to more or less the same result with significantly less words. One of the differences which I did find interesting was that the Singaporean regime, although there is a carve out for eligible financial contracts, my understanding is that that's actually quite a narrow and specific set of instruments, whereas in Australia we have a very broad carve out that applies to bonds, syndicated loans and things of that nature. there was a lot of concern in Australia before the ipso facto regime came in that applying ipso facto rules to those sorts of financial contracts in Australia could have a real chilling effect on the willingness of lenders to lend, especially if they were overseas financiers lending into the Australian market. From what I've seen to date, there doesn't seem to be a lot of discussion on the topic, at least sort of in sort of public forums on the internet about that concern in Singapore. So it seems that maybe despite the fact that on its face the ipso facto restrictions appear to apply to a broad range of financial contracts, there doesn't seem to have been the same level of sort of concern in the financial markets in Singapore that we saw here. One of the other issues that we've seen with ipso facto clauses is that they do only take you so far. They provide a sort of a temporary breathing space while the company is in whatever the form of restructuring procedure is, preventing the counterparty from terminating or exercising their rights, provided that none of the other sort of default events for sort of substantive performance have been triggered, as Aurelio mentioned. What we haven't done in Australia, and what it appears hasn't been introduced in Singapore either, is the other aspect of the treatment of contracts that you have in Chapter 11, which is the right to cure and then either sort of assign or assume those contracts once you've cured them. That's a very important tool if you're looking for a sort of a permanent restructuring of the business and you want to put leases or other contracts back on foot for the new owners of the business post-restructuring. Again, it'll remain to be seen sort of how much of a stumbling block that is in Singapore, but certainly in Australia, that lack of an assignment and assumption regime has proved quite problematic on a number of restructurings that I've been involved in. I'll finally just make a couple of comments around the sort of the COVID modifications and the general response to COVID in Singapore and Australia. As Aurelio said, there are a number of similarities in legislative approach between Australia and Singapore in terms of protection against insolvent trading and making it more difficult to wind up a company which is in financial difficulty. One of the things that's made a huge difference, I think, in Australia to the extent to which companies have been able to trade through the current conditions is the amount of government support that's been provided to distressed companies, primarily in the form of the JobKeeper subsidy, where there's been effectively a government subsidy for wages of employees of companies that are in financial difficulty. That JobKeeper subsidy is now beginning to wind down. But it looked from the discussion, and maybe this was outside of scope, that there perhaps wasn't the same degree of government financial support in Singapore that there has been in Australia. And it will be interesting to see whether that results in a different, I guess, a different path in terms of the level of financial distress and restructurings over the coming 12 months as companies try and come out of this period. The simplified restructuring and liquidation processes, there's also sort of quite a strong parallel there between Singapore and Australia. The Australian government has sort of come up with their version, I guess, of each of those things which are currently before Parliament. Again, I think it's interesting to see the sort of philosophical difference in terms of drafting and level of detail. The Australian processes are quite prescriptive in terms of a lot of the process and procedure, without necessarily the same level of flexibility that it appears is sort of built into the Singapore regime. It's particularly interesting for me to see that the Singapore regime it relies again on the scheme of arrangement as the method for carrying out the restructure or the compromise of a business going through the simplified restructuring process. In Australia, rather than using an existing regime, there sort of appears to be a new compromise regime, which, from what I can tell, sort of appears a little bit akin to a debt repayment program, which has been introduced. So it appears a lot less powerful and a lot less flexible than the scheme as a way of restructuring a company's debts. On the flip side, I do wonder whether for companies of the size with liabilities of less than $2 million, etc., whether a scheme of arrangement is a cost-effective manner of reorganising its debts. Certainly in Australia, undertaking a scheme of arrangement is a massive task, which involves preparation of a very detailed explanatory statement, the scheme of arrangement itself, the court hearings, the lawyers, all the rest of it. I think in Australia, at least, undertaking even a pre-packed scheme of arrangement for businesses of that size would probably be prohibitive in terms of cost. But it may be that the requirements in Singapore are such that it can be done more efficiently. I'm conscious that there's sort of, there's only so much time and there's a lot to cover, so I might pause there. But thank you very much again, Aurelio, for your talk. It was very interesting, and I learned a lot about where Singapore is in the restructuring in the law reform process.
I'd also like to add my thanks to Aurelio. Thanks so much for giving us a tour of so many different changes that have been coming through in Singapore, and there's so much for us to think about, as Paul's been discussing. I mean, one of the narratives in Australian insolvency law that we're seeing pretty consistently now, and certainly something that I'm mentioning every chance I get, is that in Australia, we just seem to keep adding to our insolvency laws, and we haven't had a major review, unlike in Singapore, where the review was in 2013, I think, that then led to the current reforms. Australia hasn't had a major review since really the mid-1980s, and I think it's well overdue. If we think about the way that business operates in Australia today and compare that to 1985 and 1986, we're really in a different universe. So it is something that we need. We have a pattern of people complain about things, maybe the government listens, maybe it proposes what it perceives is a solution to what people are complaining about, which is not always the same thing as what people are complaining about. And we just keep adding to the law. And even when we say it's simplified and it's streamlined and it's cheaper, it still seems to inevitably end up being 100+ pages of amendments to the Corporations Act, which is already 3,500 pages long. So it's well overdue for us to have a comprehensive review, and really for us to recognise that even though we have some successes in our insolvency laws, like voluntary administration, which we've seen recently with Virgin, can produce very good outcomes, that there's a lot we can learn from other jurisdictions. We certainly don't have all the answers, and a lot of other jurisdictions are doing some very interesting things, and there's a lot that we could learn. So thanks so much, Aurelio, for giving up your time and fitting in with our time here in Sydney. Thanks so much for Paul for your considered comments on Aurelio's presentation. And thanks to everyone who logged in. We had people on the line here from New Zealand, from Spain, from England, from Ireland, from Europe, and across the Asia Pacific. So even though we had a small audience tonight, we certainly did have a very a broad audience. So thanks everyone. This at this stage is most likely to be the last of the Ross Parsons Law in Downtown Business webinars for this year. I think we've done about 18 of them this year. So I think we might have an early break, but certainly we'll be back next year. And we'll have a range of topics, and anyone who's on the line, if you've got a particular topic you'd like to suggest, please do get in contact with me. So we'll draw it to a close there. Sorry we went a little bit over time, but we did have a lot to talk about. So thanks again, Paul and Aurelio, and good night, everyone. Thanks.
Thanks, Jason.
Thank you so much, Jason.